The courtroom became silent as the judge prepared to rule. Everyone waited for the decision. What happened next changed the entire case.
Your time's performing in front of me as well. I commend both of you for being professional, and I look forward to working through this case with both of you. Thank you. All right, to address just a couple of things, Pastor Bonner mentioned that we are the jury, and we are not the jury. My job as a judge is simply to make sure that the law is followed and that court is done in a fair and just manner. That's my role, to make sure that everyone follows the law and that everyone stays within the rules, and I make sure that that's done. We are not the jury. And as of right now, Ms. Williams did correctly state the law that this is not the trial, and
The judge explained this was not a trial. Different legal standards apply during bond hearings. The focus was risk, safety, and evidence.
And think that's where we're at today, because that is not where we are. On a motion for bond, defense has a burden of coming forward initially with evidence to show that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. And then it is the state has the burden of persuasion in convincing this court that the defendant is not entitled to pretrial release. The state has the burden of proving by a preponderance of the evidence that the trial court should deny bail or bond. And there's a vast difference in beyond a reasonable doubt and preponderance of the evidence. Preponderance of the evidence is essentially greater than 50%, or it's just a greater likelihood than the other side. That is vastly different than beyond a reasonable doubt at trial. And I need everyone to understand that. My job is to evaluate the witnesses, weigh their credibility as they testify before me, and apply what the witnesses have said and apply their credibility to the law the best I can. Make sure that I've covered what I needed to and what I've heard from several folks. All right. With that being said, and listening to the witnesses here, if I weigh these witnesses' testimonies and I weigh what I hear today, I believe.
After hearing testimony, the court announced its decision. Bond would not be granted. The defendant would remain in custody.
She would have the ability to flee, that she would be a danger to the community, that she would be a danger to them, that she would pose a significant risk of intimidating, or actually I think the state steered away from intimidating, or influencing or manipulating witnesses. By finding that, I find the state has met their burden today by preponderance of the evidence. And Miss Patrick, because of that, I'm bound by the law, and I do not believe that you would be a proper candidate for bond at this time. With that being said, here's what I want to tell you. Very recently, the Judicial Council of Georgia recognized our court as being a clearance rate excellence award recipient, which means that we are very up to date on our cases and we take great pride in moving cases quickly. I do not want anyone to sit in jail unnecessarily. So what I would like to do is go ahead and give you future court dates. And I'll explain this, Ms. Williams, a little bit because, again, I know you're new to being in front of me. But I would like to go ahead and give you some future dates for your case. obviously, your case has to be indicted first. All right, that's the first process. We know when this case will go in front of the grand jury.
The judge also promised something important. The case would move quickly through the system. Future court dates were immediately scheduled.
If they choose to no bill it, then we'll cross that bridge. But if they choose to true bill, then your case will go forward. And I've asked the clerk which would be the next available arraignment that we could place her on. All right, so, and that's not the probation counter, correct? All right, so your arraignment, if true bill, okay, I'm just giving you a plan of action so that you know what's coming up, okay? If they true bill this case, your arraignment date will be 9/22. On that date, your non-jury will be 11/17. Your calendar call will be 12/16, and I will be prepared to try your case on January 5th. All right? Now, that's incredibly fast. State and defense. I'm completely aware that y'all may ask for continuance based on those time frames. I'll need y'all to do that formally. There's a lot of interest in this case from both sides. And defense was right. Justice needs to be done. And no matter what decision was made, someone is going to feel as though justice was not served today. That's just the truth. If I would have granted bond, there would have been a large group that said justice was not done. If I deny bond as I'm doing today, there's going to be a large group that says justice was not done. That I can't avoid. But what I can do is give this young lady speedy justice. And that's my purpose. Again, my role is to make sure the law is followed, and I do the best I can to facilitate that. So, I will be ready. If state or defense, if y'all have issues, because I'm fully aware that issues come up with discovery and with cases.
Both prosecution and defense were told to prepare fast. The court emphasized fairness and speedy justice. Attention now shifts toward trial preparation.
That's in my courtroom quite often, Ms. Williams. They know I'm very reluctant to give continuances. So if y'all need that, I need y'all to file a proper motion, and it's likely we'll have a formal hearing on whatever requests for continuances need to be heard, if they're needed to be heard. If not, I'm going to stick with this time frame. Again, she's in custody, so she takes priority on my trial list, as everyone knows. Also, her age. Defense, you brought to my attention that she's in isolation, so again, it's a top priority for me to move this case as quickly as possible. I would say that I would ask the sheriff office to do the best they can to acclimate her with folks, but I know that our sheriff is going to do their very best. And I can't direct them on safety, and their top priority is her safety. Same as mine is to make sure that justice is done to the best of my ability. Hers is to keep her safe. And so we'll do that. So those are the dates. Any questions, Ms. Williams or the state, about those dates?
Not from the state.
Ms. Williams?
Not a question, but more so on the statement. I did file my entry in reciprocal discovery on July 11th, and I have not received any discovery. If the state would turn over that discovery as soon as possible, I'll be ready when January comes.
Okay. It's my understanding that this office in particular has an open file policy, so I'm assuming that they're going to probably have available to you whatever they have now very quickly. And they know my practice of moving quickly, so I think they'll try to accommodate that as well. Anything else, Ms. Williams?
No, Your Honor.
Anything else from the state?
Nothing from the state.
All right, that'll be the order of the court. Everybody has their dates. We have a plan of attack moving forward. Hope everyone has a good day.
Now everyone waits for the next courtroom battle. Evidence, witnesses, and arguments are still ahead. The final outcome remains unknown.